Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. Thank you for subscribing to my channel. If you haven't, please consider doing so, because when you help me, I'm able to help you guys. So today we're going to talk about formatting your quiet title actions, because so many people have sent me messages saying, how do I do this so that it looks good or the court won't reject it? So let's get started. Okay, so the Bible verse of the day is going to be right here, Philippians 4:13, which is, I can do all things through Christ who strengthens me. And as you guys know, when I fought my foreclosure, God helped me do it every step of the way, and in those days, we didn't have AI. Now that we have AI, a lot of people think they can do these things themselves, but AI is not going to work for everybody. You still need to know certain things about formatting your complaints. AI cannot format it for you. So let's get started in talking about what things we need to look at. Okay. Again, this is not legal advice, but if you're filing a quiet title action or defending one, proper formatting can make a huge difference in how your case is received by the court. Let's start with the court rules. Every court has formatting requirements. Your margins are usually 1 inch on both sides. The font size is usually 12 and 14 for headings. The line spacing is double spaced. The page limits, well, you want to keep it as short as you can. Caption requirements, I will show you an example. Signature blocks, remember to sign and date everything, and make sure that each page is numbered at the bottom center, which is the footer, which is what this looks like right here. Okay, so formatting seems to be the biggest problem people have. I think Chat, GPT, and other legal places, when they give you something, it's single spaced, which is what this looks like here. But the reality, it must be changed to double spaced. I like to use a word processing program called OpenOffice. It's just like Word, but it's free. Before you write a single word, however, download your court's local rules. And you want to build a proper caption. And here's an example. The caption includes the court name, the parties, and a place for the case number and the document title. And for a quiet title action, you want verified complaint as your title. And as you can see here, this is just an example for the General District Court of Prince William County, Virginia at the top. This is going to be a state court filing. It has a place for the case number on the right, and then your name would be there on the upper left corner as the plaintiff, and you're suing, let's say you're suing PHH Mortgage or US Bank for XYZ Trust, the defendants. So that's how your caption should look in state court. And then the federal court version is almost the same, except you want to use the federal court at the top of your caption like this. In this case, here's an example of the United States District Court for the Middle District of Florida, Orlando Division. Again, you've got to leave space for the case number, etc. Okay, so the structure of your complaint should be as follows. You want parties, jurisdiction, property description, factual allegations, causes of action, and prayer for relief. Let's keep this organized. Here's some formatting tips. You want to number each paragraph. Here's an example. This is starting with parties. Number 1, plaintiff, your name here. And it explains, you're a natural person and owner of the residential real property known as, and you put your address there, the property. Plaintiff is a consumer borrower who executed residential mortgage loan secured by the property. Number 2 is the defendants. In this case, we're just using an example here, which is the US Bank for the CVICGS Mortgage Loan Trust, which is an XYZ Trust. And again, that's that. Now, jurisdiction and venue is the next section. It should look something like this. Again, everything is numbered in sequential order. You can't just start renumbering order. It has to start from parties and end at prayer for relief with the numbers. So basically, jurisdiction and venue, and it basically you want to say why you're in that jurisdiction. This court has subject matter jurisdiction pursuant to 29 U.S.C. 1331, because plaintiff's claims arise under the laws of the United States, including but not limited to, and this is for federal court, guys, RESPA, Regulation X, and federal laws. So we're saying that the federal court is the correct jurisdiction, and then also the court has supplemental jurisdiction over plaintiffs' related state law claims pursuant to 28 U.S.C. 1367, because those claims form part of the same case or controversy as plaintiff's federal claims. So this is basic stuff, guys. I know chat can probably give you something very similar, but you want to make sure to keep it double spaced and everything numbered like this. And you can also put something about the jurisdiction is correct because declaratory relief is authorized pursuant to 28 U.S.C. 2201 and 2202 as an actual, present, and justifiable controversy exists between plaintiff and defendants regarding defendant's claimed right to own, service, modify, or enforce a mortgage loan and the security instrument encumbering the plaintiff's property. And then comes the venue, right here. Venue is proper in this judicial district pursuant to 28 U.S.C. 1391b because the real property that is the subject of this action is located within the district and substantial part of the events or omissions giving rise to the claims occurred within this district. And you basically want to say what your address is, and the defendants transact because this district is a service mortgage loan secured by property located in the district, recorded documents in the public records of your county or state. Okay, so you're saying that they have jurisdiction and venue. Now, next section is property description. Now, this is where you put your legal description to your property, which is the legal description is usually found in your warranty deed, or it's also in the mortgage or deed of trust as a legal description, and it sounds something like lot 35 and plat, this or that. Anyway, you want to put that in there. Then you put your factual allegation section, and here's some factual allegation tips. Okay, tell us the story in chronological order, stick to facts, not opinions or conclusions, use short numbered paragraphs, identify the who, what, when, where, and how. Reference important exhibits when applicable. This is where you put your exhibits, like see Exhibit A, the warranty deed. Okay, avoid emotional language and personal attacks. Include only facts you can prove with evidence. Separate factual allegations from legal arguments. Be specific with dates, documents, and communications, and make it easy for the judge to follow the timeline. So here's an example of factual allegation section. It has a subheading that says purchase of property and origination of the loan. And then it says on the first line under number 15, plaintiff repeats and realleges paragraphs 1 through 14 only to the extent necessary to provide context for the factual allegations set forth below. And here comes the who, what, why, and all that stuff. On or about November 24, 2020, plaintiff purchased a property located at your address here by a special corporate warranty deed recorded in the public records of your county, your state here. See Exhibit A, warranty deed. In connection with the purchase, plaintiff executed a promissory note and mortgage in the original principal amount of, and this one says $250,660 in favor of, and then you want to say your lender here. It could be PHH Mortgage. And it's saying the mortgage identified Mortgage Electronic Registration Systems, Inc., MERS, as mortgagee solely as nominee for your lender and its successors and assigned. See Exhibit B, the mortgage. So you see how the factual allegation section is. It's in chronological order, numbered paragraphs, short, plain statements. That's what you want. And remember that the factual allegation section is where you tell the court what happened. This is not the place to argue the law. Think of yourself as a witness writing down the facts in a clear, organized, and chronological manner. Save your legal arguments for the cause of action in the next section. So let's talk about the cause of action section. Okay, so cause of action tips. Create a separate heading for each cause of action. Clearly identify the legal claim being asserted. Incorporate the factual allegations by reference. State each required element of the claim. Connect specific facts to each element. Cite relevant statutes when applicable. Avoid repeating all the facts under each and every claim. Be concise and organized. Include only claims supported by the evidence and request the relief associated with the specific claim. So here's an example of a cause of action section where it says count 1, violation of RESPA and Regulation X, and this is against PHH Mortgage Corporation. And again, it's saying plaintiff incorporates by reference paragraphs 24 through 38 and 42 through 44 of this, and this was taken from a First Amendment complaint, but it could be original complaint, which sets forth the factual allegation relevant to this count. And again, this is where you want to tie everything in the factual allegations with your cause of actions and how they violated this. And you can say on multiple occasions, including through written disputes and requests for information, plaintiff submitted qualified written requests and notice of error concerning, among other things, the identity of the lawful owner and holder of the promissory note, the authority of any entity or service to modify the loan, and the FHA status of the loan and post-closing cancellation of the FHA insurance. Okay, so the cause of action section is where you connect the facts to the law. The factual allegations tells the court what happened. The cause of action explains why those facts entitle you to relief. Each claim should stand on its own, identify the legal basis for the claim, and show how the facts satisfy the required elements. A well-organized complaint makes it easy for the judge to follow your reasoning and understand exactly what relief you are seeking. Now, the prayer for relief section. Here's some prayer for relief tips. Clearly state exactly what relief you are requesting. Be specific and avoid vague requests. Number each item of requested relief. Request declaratory relief when appropriate. Request that clouds on title be removed. Request that adverse claims be declared invalid. Include a statutory relief authorized by law. Any statutory relief authorized by law. Request cost if permitted by statute or rule. Include a request for any other relief the court deems just and proper. And make sure the requested relief matches the causes of action asserted. And this is what the prayer for relief section should look like, where it says, wherefore plaintiff respectfully requests that the court enter judgment in plaintiff's favor and against defendants and grant appropriate relief, including a declaration that no defendant is the lawful holder of the promissory note and that defendants lack standing or authority to enforce or modify the loan, and that the recorded assignments of mortgage are ineffective to confer enforcement rights, that the recorded loan modification is void or unenforceable, and that the plaintiff remains entitled to protections afforded by FHA loan documents executed at origination. Plaintiff further seeks an order requesting order quieting title to the property in plaintiff's favor and directing that all offending recorded instruments, including the challenged assignments, and basically it says, and the loan be declared null and void. The prayer for relief is where you tell the court exactly what you want it to do. Don't assume that the judge knows what you're asking. Be clear, specific, and organized. And if you're filing a quiet title action, you may be asking the court to determine ownership interest, remove clouds on the title, declare adverse claims invalid, award costs, and grant any further relief that the court deems proper. A strong prayer for relief should match the facts and cause of action set forth in your complaint. And your complaint should also include a verification section. A verification is a sworn statement that the facts contained in the complaint are true and correct to the best of your knowledge. Many quiet title plaintiffs choose to verify their complaints because it demonstrates that they stand behind the factual allegations under penalty of perjury. Before signing a verification, carefully review each factual allegation and exhibit. If you are verifying the complaint, make sure everything is accurate because your credibility is one of the most important assets in court. And this is kind of what it looks like. An unsworn declaration under penalty of perjury, where it says my name is, and you put your name there. My address is, you put your address. I declare under the penalty of perjury that the foregoing statements contained in this verified complaint are true and correct to the best of my knowledge and belief. Entered in your county, Florida on blah blah day of blah blah blah. And then you put your name there. Now, exhibits is the next section. Exhibit tips. Label each exhibit clearly, Exhibit A, Exhibit B, Exhibit C, etc. Refer to the exhibits in the body of the complaint. Attach only exhibits that are relevant to your claims. Organize exhibits the same order that they are referenced. Include complete and legible copies whenever possible. Highlight or identify important provisions for easy reference. Use exhibit cover pages when appropriate. Again, you got to use exhibit cover pages for each exhibit. Ensure exhibit descriptions match the actual documents. Remove unnecessary or duplicate documents. And always review your exhibits carefully before filing to confirm nothing's missing. Here's what an exhibit cover page looks like. It says Exhibit A, and in parentheses is the warranty deed. So you're saying what Exhibit A is. And then right behind it is where you put your exhibit. Okay. Other filing tips? Well, print all court filings and exhibits single-sided unless local courts permit otherwise. And by the way, I've never seen a local rule where they want it single-spaced. It's always double-spaced. Review every exhibit to make sure it's complete, legible, and easy to read. Sometimes when you print out exhibits, they are not as legible as they would be, so always double-check that. Read your complaint several times before making sure you have not left out important facts, parties, or claims. And then once you've gotten to that point, make at least 3 copies of everything. 1 for yourself, 1 for service, and 1 for your records. Double check all dates, names, addresses, and exhibit references before you file. Number all pages. Again, numbering is important. And keep documents organized in logical order. Bring extra copies to hearings when possible. Confirm your filing fees and local court requirements before going to the courthouse. If you are seeking emergency relief to stop a foreclosure sale, be cautious about filing in forma pauperis because the clerk may delay issuance of summonses or processing while the application is reviewed. Keep a complete copy of everything you file, everything you receive from the opposing party as well. Now, one of the biggest mistakes pro se litigants make is focusing entirely on legal arguments while overlooking the basics. Make sure your exhibits are readable, your complaint is complete, and your copies are organized. Always consider your timing and deadlines before filing. Good organization and attention to detail can save you a lot of headaches later. Okay guys, that does it for today's episode. I hope this was helpful to some of y'all. And if you have any questions or comments, you can leave them below, or you can send me an email. My email address is foreclosurehelp777@gmail.com, and it's spelled just like this, with the number 4. And as always, everyone have a blessed day.